this session is about what is building control and what are the building regulations. So many people confuse building regulations with planning. And I think the first thing I need to sort of highlight and sort of press down really is that planning deals with what things look like and their impact on their surroundings in a sort of social economic sense and various other senses. Building regs is all about the mechanics and the construction of how things are built. So we're the meccano and we don't really mind what it looks like. That's planning. So planning is what it looks like and how it sits in the community. Building regs is about how you build it and what it's built with. What are the building regulations? So the building regulations are minimum technical standards set by government, and they cover the construction, extension, alterations of most buildings. They're intended to protect the health, safety and welfare of people in and around those buildings. And they also set standards for some sort of more touchy-feely things or sort of moral-based things around accessibility, things like water use, energy use, security, and things like that. So what things need building regulations approval? And I kind of tongue-in-cheek kind of say to people, a lot of people think it's just structural things that require building regulations approval or new buildings, and that's not unfortunately the case at all. The regs have changed massively in the last few years and are increasing to change at an ever faster rate really. And I have to say to people tongue-in-cheek that if it doesn't say paint on the tin, then potentially building regs could apply, because it applies to a whole host of different works and alterations and all sorts of things. So I'm going to list through some of the things that building regulation approval covers, or that you need building regs approval for. So the first one is perhaps the most obvious example. It's things like extensions in new buildings. So that's domestic or commercial, doesn't make any difference. So most extensions and most new buildings require building regulations approval. There are a few exemptions, but they're very specific, and it's always best to check with us first, because it's not often that the exemptions apply. So the next one relates to something called a controlled service or fitting. So these are things like boilers and things that create heat, so log burners, boilers, air conditioning systems, that kind of things like drainage, things like electrical services in some cases, and chimneys, those sort of things. So they're bits of the building that perform particular functions. So they're described generically as controlled service or fittings. And if you provide one or extend one of those, so drainage is another one, if you extend your drainage system, that's controlled under the building regulations, and it requires a building regulations application in most cases. If you alter a building or a controlled service or fitting in certain ways, so certain alterations to buildings, or those controlled systems in those buildings, can also require building regs approval. So I'll come to some examples of those in a minute, but that's one of the bits that often catches people out. People think if this alteration is not structural, it doesn't require building regs, and unfortunately it's not as simple as that. So another one that catches people out very regularly is when you change the use of a building. So if anybody's had anything to do with planning, you might be familiar with a change of use under planning. Well, there are also changes of use under building regulations, and they are different to changes of use under planning. So, and this applies sometimes if you change the use of part of a building as well. And the building regulations describe what all these different types of changes of use are. I'll come to those again in a minute. But this catches people out. And what this says is you need building regs approval and probably have to upgrade that building or that part of the building because you're changing the use of it. If you're putting insulation into the cavity, that requires building regs approval. There's a particular kind of scheme to deal with this that people who do this kind of work can sign up for, that avoids having to make a proper building regs application. There's a different way around that, but it's controlled work under the building regulations. So that's things like blowing fluff into your cavity walls in your house. If you're underpinning a building's foundations, so say you've got some subsidence or there's something happening under the ground which is causing the building to become unstable, and you dig holes underneath the foundations to pour extra concrete in to make them deeper, or you drill piles, or you do other strengthening works, these also typically require building regs approval. An interesting one that catches people out, particularly with commercial buildings, is if you change the energy status of a building. So if you've got a building that was unheated or uncooled, i.e. it had no air conditioning and no heating systems in it, no fixed systems, and you're adding them, you are changing the status of that building from being an unconditioned building to a conditioned building. So for example, unheated to heated or uncooled to cooled. That requires building regs approval, and you're required to upgrade the insulation because you are in effect now conditioning that space, and it's reasonable to provide some insulation to make that easier to do and efficient to do. Works the thermal elements of a building. Again, this is relatively new into the building regs. It's been around for a few years, but people are still struggling to get their head around this one. So if you've got a wall or a roof or a floor, and you are doing work to more than certain percentages of those elements of the building, because they're thermal elements, they're part of the envelope of a building that keeps the heat in or the cold out, or however you want to look at it. Those can often require building regs approval, and you might be obliged to upgrade the insulation to that wall because you're doing works to it. And there's another sort of strange one. This is for larger commercial buildings typically, and this is when you're doing work, sometimes the building regulations require you to do some more work. So if you've got a very big non-domestic building and you're spending quite a lot of money on it for something, the law requires you to potentially spend another 10% on what you were spending anyway to upgrade another bit of the building you weren't necessarily touching. And this is quite an interesting one. This is the government's aim to effectively, if you like, accelerate upgrade of certain building types. So you have to do extra work as a consequence of the work you were intending to do. And this is one that catches sort of larger buildings out sometimes, and can be quite tricky to work around, but it's worth highlighting here. So to give you a bit more of an idea what some of those types of work look like, here's a sort of split down list of some of those types. So basic building work. So as we talked about, underpinning, adding insulation, removing internal walls. So I was talking about those controlled alteration works that you were doing. If you're taking walls out, whether they're structural walls or they might be walls that change the disabled access of the building, the accessibility of that building, or they might be walls that have some function in terms of fire or means of escape. So getting out of that building in the event of a fire, escaping from that building safely, and that might be to hold fire back, to create a protected space or corridor, or it might be to control smoke even. Removal of internal walls can often require building regs consent, even if they're not structural. And quite often, a lot of the walls that we deal with aren't structural walls. They might be both, but a lot of them have their primary function is actually fire. If you're altering toilet accommodation, so replacing a sink is one thing, but if you're starting to move things around in that space, and it's a non-domestic building particularly, and also it applies to some domestic works, that requires building regs approval because you are changing the accessibility of that facility for maybe a wheelchair user or somebody with some maybe accessibility difficulties. And then also any other alterations which affect that building in terms of its accessibility. So if you're in a commercial building, you're changing the entrance door, there's a requirement for you to try to make that entrance door more accessible than it might have been before, for example. I talked about those changes of use. So these are some typical examples of change of use. So again, you might have needed planning permission for this, but you also need building regs approval for this. So this is where you've got a building that's a dwelling or a flat and it wasn't previously. If you're changing something to become a hotel or a boarding house and it wasn't that previously, again, that's a change of use, and the regs require you to upgrade the building in all sorts of ways because you're changing the use. Again, it's a way to accelerate the government's idea to accelerate sort of the upgrade of building stock, and to make sure when you change the use of a building that it's kind of upgraded to reasonably modern standards. An interesting one is public buildings. Certain types of buildings are classified as public buildings. Libraries is perhaps a good example, but there's a whole load of other types of public buildings that, again, you're changing that use. You might be required to upgrade the building because of the way you're changing. So you might have not been planning to do any building work. You're just going to use the building differently. The reg says you need a building regs application, and you might have to upgrade that building in all sorts of ways. We talk about institutions. Those tend to be places where people under 5 are cared for, so sort of care homes, nurseries, things like that, or people who have some sort of disability. So again, if you were turning a hotel into certain types of care accommodation, that might be a change of use. Again, we start to get quite a few of those with the pressure that we have on the care sector, and people are buying hotels and trying to change them into sort of care or other type of sort of aftercare facilities. And again, another typical one is if you have a building and you're turning it into a shop and it wasn't previously, again, change of use. We talked about new buildings. There are some types of building that are exempt from building regs, but that's kind of a whole subject in itself, so I won't get into that too much. But almost all new buildings are going to require building regs consent. Extensions, we talked about that already, fairly obvious example, and again that applies to domestic and non-domestic buildings unless that extension is exempt, and that covers certain things like porches and conservatories. Below a certain size, I should highlight, and at ground level. But again, if you're not sure, check, because there's all sorts of limitations and caveats around that. And I talked about this before. If you're changing the energy status of a building, you're providing cooling or heating for the first time, or significantly changing how much you're cooling or heating that building, again, that might trigger a change in energy status. And again, the requirement for an application. So if you've got one of those scenarios, how do you make sure you comply with the building regs? So this is kind of an rough order of what you'd need to do typically. So the first thing you need to do, and particularly this applies for non-domestic buildings, so any type of commercial premises, you need to find a principal designer to advise you on how to do this. A lot of people kind of strangely go to a builder first. Now, builders are great, but often their knowledge is based on what they built last, which might not be the same as what you're doing. So builders are kind of often the end of the information chain, and maybe aren't the best person place to give you that kind of advice. So principal designer might typically be an architect, surveyor, an architectural practitioner. There's all sorts of people who sit in that space, and depending on what type of project you're working on, you might choose a different person or person with different skill set. But they are there to help you design what you're doing and to help you make that building regs application and demonstrate compliance to us. So once you've got that designer, you would then draw up some plans and some information, and you would submit an application for building regulations approval with full plans. Now this confuses people because we talk about full plans. This is not a planning application, it's a building regs application, but it's using plans and paperwork, if you like, or digital paperwork, to describe what you're doing. And that might be drawings, that might be photographs, that might be some specifications, some technical information, some product information. You're describing and explaining to us what you had before, what you're going to have in the future, and how you're going to make that comply. On our website there's a web link. There's a lot more information about that process because it's quite complicated. And again, that's why you typically might find you need the help of a designer who's familiar with that process and what sort of information we're going to be looking for. So that process, you would provide us essentially, as we say there, a set of plans and details for the works. We would then check that information on paper. It would obviously be on a computer these days, but it would be those documents to ensure that what you're proposing to do is going to comply as far as we can understand from the information. We might ask you for some more information. We might suggest you need to change certain things because they don't show compliance. So we go through a process to make sure that that information shows compliance. We might also, and in fact we always, for non-domestic buildings, we consult the fire service as well, because their legislation takes over once your building is occupied in terms of fire safety, and the building regulations and the fire safety legislation overlap. So that's to make sure that what we're approving also satisfies the fire authority's requirements once your building's occupied. So once you've got an approval, once we've approved that information, you can start work. We have a team of site inspectors operating across the whole of Cornwall every day. We've got about typically 12 people on site every day across the whole of Cornwall, and they will inspect certain stages of the work as you progress on site. And those stages, typically quite a lot of them are kind of groundwork stages. If you're doing an extension or something that involves digging in the ground or putting pipes in the ground, there's quite a lot we see at that stage. But there's also a lot of stages we look at above ground, sort of the superstructure of a building, and things like fire stopping and insulation and sound insulation and all sorts of things like that. So every project we will decide what stages we want to look at, and you have to tell us when you reach that stage, and we will come and inspect it before you progress forwards. And then once the project's finished and you provided all the information to show that what you've done on site complies, and we're happy with the inspections we've done, we issue a completion certificate. So where does all of this come from? Why do you need to do this? So this essentially comes out of some the key piece of legislation is called the Building Act 1984, and that's been recently significantly changed as a result of the Grenfell Tower fire. So the Grenfell Tower fire resulted in something called the Building Safety Act, and that has had massive change on the Building Act in the last 2 years, really. So that act, although it originated in 1984, has been massively amended in the last 2 years. The Building Act is the basic law, and underneath that there's the building regulations, which have also been massively amended, and they kind of tell you in a bit more detail. They describe, for example, what change of use is. They describe what type of work requires building regulations approval, and they describe the process of building regulations approval, and also what to do when it goes wrong. Underneath that, we have something called the approved documents, and they're published by government, and they're kind of manuals that explain in a bit more detail how you might functionally go about complying with the requirements of the building regs. I'll come to that in a little bit more detail in a moment. Those approved documents, if you like, are kind of a simplified sort of a Haynes manual, but without the drawings sometimes, of roughly what you're trying to achieve. So maybe a bit like a sort of service standard manual that a garage might use to decide what to look at when they're servicing your car. In those books, it might refer to British standards. There are a massive number of British standards, and they deal with all sorts of things. And the approved documents might refer you to some for more information or an alternative way of showing compliance in some cases. And all of this overlaps with something called the Regulatory Reform Fire Safety Order, which the Fire Brigade enforce, the Housing Act, which the council are involved in as well. So that's to do particularly with privately let properties, but any house technically it would cover, and things like the Health and Safety at Work Act. So once your building's finished, if you're operating a business in it, you've got to meet certain health and safety requirements as a business. So there's a kind of parallel. It's meant to sort of join up in terms of the standards the building regs is asking for should in most cases satisfy those other bits of legislation as well. But there are some bits that aren't as well tied together as we might like. So I was talking about those approved documents, those kind of guidebooks. Well, this is one. This is approved document B. It's one of two volumes. One deals with dwellings. One deals with everything that's not a dwelling. And these are guidance books. They're freely available. You don't have to pay for them. You can download them or view them online. And these describe in a bit more detail what sort of things you need to achieve this thing. So part B, as we call it, approved document B, relates to fire safety. And as you can see there, it splits it down into different themes within fire safety. So how do you get out of the building, means of warning and escape, things like the fire resistance of the structure, things like fire brigade access. And this book splits down into more detail what you need to achieve functionally and how you might go about doing that. So it's not a kind of recipe, but it's a kind of specification, if you like, for what sort of stuff's involved. They're fairly practical, but you would struggle if you've never looked in one before to get your head around what it actually means, because you might have to look at a whole load of other information to work out how to meet the requirements of this book. And these approved documents cover a whole load of themes, and we call them parts A to T of the building regulations. A is structure at the top, B is fire, as you can see here, and the last one is part T, toilets. That's a very new one. And it covers all of these subject areas. So not all of these apply to all types of building work. Some of them apply to all types of building work, some apply to certain types of building work. But these are kind of the themes that we're looking at in a typical building regulations application. As you can see there, it's pretty varied. We're looking at fire, sound insulation, ventilation, accessibility of doors and corridors and toilets and things, things that burn fuel, security in some types of buildings, digital communications is a new one, car charging is a new one. There's a requirement to provide electric vehicle charging in many cases, and also toilet provision, which is a very, very new one, and that's the government's aim to reintroduce a balance of single-sex toilets as well as accessible toilets and potentially unisex toilets as well. So that's quite a new bit of the building regs and is perhaps a little bit contrary to what some people might have imagined the government would be asking people to do. So perhaps this is an important question for a lot of people to ask, because a lot of people do find themselves asking this question: what to do if there's no permission but the work's already done? So technically that's an offence, but we'll put that to one side for a minute, because perhaps more important thing is how to deal with the actual problem. So there's a type of application we have for retrospective works, and that's called a regularization application. It's slightly different to the other application types, but it's basically a retrospective application for building regs. So you can submit one of those. We might ask you to open up the works or provide details about the work. So obviously we haven't got X-ray vision, unfortunately. So you know, often the only way of knowing what you've done is that it's opened up, or drill a hole through it, or cut a bit out so we can see. So we can understand what you've done, and then we might ask you for some more information about what you've done, or proof that you've done that, maybe receipts or photographs or whatever. And if that work complies, that might be fine. But if there's fundamental issues with that, we might then ask for some information or redesign needed to kind of sort that problem out, if you like. So that can vary from quite a simple process to a very, very complicated process. And it all depends on what you've done. An important thing to mention is you should tell your insurance company. Technically speaking, most people's insurance policy will say that if you don't have building regs approval for the works, your whole building's not insured. And I can tell you for a fact that insurance companies like that one, because it means they can decline to pay out on your insurance in the event of a claim. So you probably need to tell your insurance company, and they might charge you extra until you've sorted it out. If you don't tell them, you probably don't have insurance. And there's a lot of unauthorized works out there, and therefore there's a lot of uninsured buildings. And obviously insurance companies are keener and keener to find your unauthorized works so they don't have to pay out on your insurance. And you've got tenants, you need to tell them, you need to communicate with your tenants, because they might be affected by that work, and their fire safety plans, for example, might be dependent on some assumptions they've made about the building, which are wrong. So you need to communicate with them, involve them in that conversation. Moving on a bit now, one of the big changes that building control and any building control profession in the UK has had over the last 2 years is, I was mentioning those big changes to legislation. Well, one of those is that the Building Safety Regulator has been established. So that's now part of the HSE, the Health and Safety Executive, and this is a new regulator. So they've never existed before, and they have a number of functions, and the three primary ones are these. So they oversee the safety and standard of all buildings. So that includes overseeing myself and Sarah and Cornwall Council Building Control as a building control provider. So they are our regulator, they regulate us, and we have to do a whole load of stuff that we didn't have to do before to prove to them that we're doing that job competently and correctly. The Building Safety Regulator also are the nominated building control provider for certain building types. So certain high-risk building types are nominated as high risk, and the Building Safety Regulator is the mandatory building control provider for those buildings. So you wouldn't come to Cornwall Council, you would go to the Building Safety Regulator if you needed to do work on those buildings. And typically there's a load of different types of buildings that fall into that, but it's generally tall buildings and the buildings with certain use types which are higher risk. And the regulator's third thing, and this is perhaps where it affects all of you listening today more than anything, is that the regulator has a significant role in improving the competence of all people responsible for designing, building or inspecting building work, and also to make sure that the new rules are followed to ensure that buildings are regularly inspected and they remain safe. So the role of the regulator is partly the building control process and the competency of the people involved in doing that building work or designing that building work, but also those buildings once they're finished. So as I talked about, if it's a high building, the regulator is the building control authority for those buildings. So those types of buildings they have to be at least 18 metres high or at least 7 stories. They must contain at least 2 residential units, and it includes also care homes and hospitals that meet that same height threshold. The difference is that the first 2 types of buildings, or the first type of building, I should say, that the tall buildings with 2 residential units, the regulator also has an involvement in control of those buildings after they're finished, throughout their life. And this is kind of to pick up where the Grenfell Tower kind of failed miserably, is that the work was done, but nobody was really managing or overseeing the management of that building after work had been completed. So the regulator has a role in those building types after the work's done as well, in perpetuity. For hospitals, there's other arrangements in place already for when the work is finished. So the regulator is involved in overseeing the building work, but once the work's done, in hospitals and care homes, a different arrangement takes place to make sure they continue to be managed appropriately. We don't have many of those in Cornwall, but we do have more than you'd think. There are quite a few blocks of flats and things with split levels or lower levels at the back that exceed that 7-story height threshold when you factor in kind of semi-basement levels and various other things. So there are a lot more than you would think in somewhere like Cornwall. A key bit probably for everybody listening today is to really take a focus on this slide. So part of the major changes of the regulations and also the regulator is that they've imposed these new principles of duty holders. So it's not a case of it wasn't me gov anymore. The legislation says it is you, and often it's you whether you like it or not. So it pins the tail on the donkey in advance of the problem, and that's the way I like to think about it. So there's a duty to comply. Certain people in the equation, the building owner, operator, designer, and contractor, have a duty to comply. And this wasn't really set down in legislation before. It was very woolly, but it has now closed that loop. And it says those people have an explicit duty to do certain things to make sure their work and their building is compliant. So this is a major change. It's kind of saying you're guilty in advance, almost. That's probably the wrong way to think about it. But it's saying you are responsible rather than anybody might be responsible, which is kind of how the legislation used to be worded. There's also an explicit duty to be competent. So even if you just own a building, you have a competence duty upon you because you're a duty holder. And that duty, as the owner of a building, is to make sure that the people you engage to help you that you've gone through a reasonable process to make sure those people are competent to provide the help you're asking them to. So is your designer competent for non-domestic building work, for example? Have they worked on those kind of buildings before? If you've got a weird building, are they familiar with that type of construction? Do they know what they're talking about? Are they qualified? Have they got insurance? Where's the evidence that they're qualified? Do they keep up to date with stuff? Those kind of things. And the same for contractors that you might appoint. Do they know, and this is a major problem because a lot of contractors aren't qualified. They have no formal qualification in many cases. So this is the start of quite a step change in our industry. So there's these duties about competency, but there's also a duty on all of those parties to cooperate, coordinate, and communicate. So you can't say, well, I forgot to tell Bob about this thing in my building and he's designed it without realizing. You have a duty to communicate information about your building, and those people you engage have a duty to communicate between each other and back with you again as the client. The aim of duty holders, as I said, this is a major shift with the industry, and it's essentially set to try and make building work more compliant, but also if it goes wrong, so that it's easier to know who you take to court to wag the finger at. So it really is the onus of all of us to get our head around this and appreciate that we all have duties, whether we like it or not. And it's interesting. I think the third point there is quite important. So it's the onus will fall on everybody to demonstrate compliance and maintain the evidence, not just on a building inspector to find non-compliance. So a lot of people think, well, if building control don't spot that I did it wrong, that's all right. No, the duty is on the people doing the work or commissioning the work to make sure that work complies. I've talked a little bit about principal designers and contractors there. So these are people who you appoint as a building owner to help you design the building or to actually carry out the construction work. And I'd highlight, if you've got a non-domestic building, you really need to think about potentially going to a designer before you go to a contractor. A lot of people seem to be missing out the designer at the moment. And unfortunately, the contractor is likely to be the least well informed about the legislation and what they've got to comply with. And the government are struggling with how to sort of communicate this to the contracting industry, because a lot of this is still kind of unknown changes as far as they're concerned. This hasn't really reached their radar yet, so we're doing all we can to kind of cover that off, but it's a very difficult industry to sort of to group together and tell, whereas designers tend to be more engaged in kind of learning and stuff, and it's easier to communicate with them. Consequences of non-compliance. So we've got some new powers as a building control body. We can now issue compliance and stop notices. So we can actually basically say, oi, you've got something wrong, you need to sort this out. If you don't, we can actually stop work on site. We didn't used to be able to do that. as I've said before, if you've got non-compliance, beware, you might have an insurance problem. This is a scary bit. There's now the risk of imprisonment and unlimited fines under the Building Act. This wasn't really the case before. It's now tightened this up significantly. There are now kind of uncomfortable consequences of getting it wrong. And as I say, these are quite a big change really across, or this consequence is hopefully going to drive significant change in the industry, and should stop things like Grenfell Tower happening again. It's worth highlighting really what building control are not as well at this point. So, as I think I mentioned a moment ago, our inspections are risk-based spot checks. We don't see everything. We're not meant to see everything. We're meant to do risk-based inspections at certain stages to do a reasonable process to verify that what's going on site is compliant. But, important point, we're not clerk of works. It's your duty to demonstrate compliance, not our duty to catch you not complying. So we'll do what we can to check stuff at sensible stages. But the point there is, if you've done something, we might not see that thing. You might have covered it up, or it might, that stage might have been passed. If it later transpires as an issue with that bit, it's still your duty to make it comply. So it's your duty to know what you're doing, or have helped to help you know what you're doing and make sure you comply. Regular problem we have is people want us to adjudicate on party wall matters. So this is where you've got a boundary wall between you and another building, perhaps, or a party wall in the house between you and another terraced house. Civil matters about whose right it is to do what to that wall, not building control. That sits under something called the Party Wall Act, which is a civil act. And to highlight that we're interested in technical compliance with the minimum standards. We're not interested in decorative issues. So you could have really quite wonky render on your wall. If it's stuck appropriately and it sheds the water okay, that's fine. What it looks like isn't a matter of interest for building control. Does it technically do the job it needs to do, for example? So the quality of your paintwork, not a building control issue, unfortunately, or fortunately for us. So just to summarise then a couple of points. When you're starting building works, remember, duty holders are required to ensure they have competence to carry out the design and building work they're engaged to do. And they're also required to only undertake work within the limits of their competence. The client, meanwhile, must take all reasonable steps to satisfy themselves that the duty holders are competent, so the people you're employing are competent for the work. And technically, you have a duty to refuse to accept if you're a designer or a contractor and you're asked to do a job that's outside your experience or comfort zone, you have a duty to refuse that invitation to do that work. Say, no, that's outside my capabilities. I think we all know builders that have pound signs in the eyes and will jump on, yeah, I can do that, yeah, done lots of that, and then you discover they've never done any of it before, and they're sort of making it up as they go along. And duty holders are required to cooperate with other duty holders and to communicate between each other. So these are important things you need to get sorted really before you start doing work. Find the right people to help you. So that was a bit of a whistle stop through building control. So rather a lot to take in there. I don't know if we've got any questions, so I'm just going to stop sharing a minute when I found.
So Noreen's asked about building control fees.
Do you want to cover that, Sarah, or shall I?
I've got noise in the background, so if you wouldn't mind.
Okay, so we are required by law, in effect, to cover the cost of providing the building control service. So there are regulations around this that we work around, and they allow us to set a set of standard fees for certain types of common work we deal with, and also bespoke fees for unusual stuff that sets outside those kind of common work type space. I'm a bit where my camera on my end's gone a bit glitchy, so apologies for that. But if you can hear me okay, is the audio all right?
Yep.
There's a lot of people on the call, so it's struggling a bit. But so there are building regs fees. Unfortunately, we have to charge for our time. It's not free, but we are a cost recovery service. What we charge is intended to cover our services. I would highlight that if it's a retrospective application, so you've been naughty, you've done the building work, now you're trying to sort it out afterwards, the rules allow us to apply a surcharge to that. So it's basically a slap over the wrist kind of element as a penalty to the fee. So we typically charge more for retrospective applications, although VAT doesn't apply to those. It is worth bearing in mind it will cost you more if you do it afterwards in every respect. So it's better to get yourself sorted out and get an application in before you do the work, get the right design information, because it should be cheaper in terms of building regs fee. Hopefully that covers that one, Noreen.
So we've got one about agricultural buildings.
Okay.
So agricultural buildings can fall into class 3 exempt buildings, but they need to be specifically used for agriculture. So there is some guidance notes in the building regulations about the type of agricultural buildings that would fall into that category.
Yeah. So and the use of agriculture does include certain horticultural uses as well. Greenhouses, for example, would typically fall into that agricultural kind of zone, but it is quite specific as to what is agricultural use. Again, be very careful. A lot of people out there, particularly people who've been sort of in the farming industry, assume that everything on a farm is exempt, and fortunately it's not the case. Only certain building types are, and there are caveats on those as to what makes them exempt and what doesn't. And there's also kind of sort of case history and various other things in that space as well in terms of how we interpret that. So
and we just moved up. So are there any time limit on building regulation certificates? And if something was issued several years ago and now the regs have changed, so there's a time limit to start works, but once you've got your completion certificate, the building regulations can't be imposed on you if you haven't done any work. But sometimes things like the RRO, the regulatory fire safety order, sometimes could impose extra things if you're using the building for commercial purposes. What else have we got? We've got, how do you assess the risks between different user groups in commercial buildings?
Yeah, so the building regulations makes provisions, particularly approved document B and the guidance that goes with that, because there's a lot of other British standards allied to approved document B, which deals with fire safety. So the risks in commercial buildings are generally fire rated ones. That's where that probably sits. And these rules about how big compartments of the building, so bits of the building that are not separated from other bits with fire rated partitioning or walls or ceilings or roofs or floors or whatever. So the idea is buildings above a certain size or with significantly different risk uses within them in a fire sense, you split down into 4 smaller boxes. So if a fire starts in one of those boxes, it's contained in that box within the building for a period of time to allow you to hopefully put the fire out before it spreads to another bit. So that's different to things like an escape stair. That's a different thing. This is about splitting a building into chunks so that you contain a fire in a chunk just to stop it setting alight the whole building. And the way you chunk up a building is driven by different risks, different occupancies, subtenancies, things like that. And it's quite complicated, but to give you an idea, that's roughly how that works.
And we've got a question around principal designers and contractors. Are these defined the same in the CDM regs? Unfortunately not. The government have used the same definition or the same words, but they haven't actually. They don't have the same definitions. So you have to go to the building regulations for the definitions.
They're not dissimilar. It's worth saying that they're not massively dissimilar. There's a sort of a parity, but the rules about what goes with those duty holder things differ slightly, and when they kick in. So there's things in the building regs that say if you're a domestic client and you haven't appointed a designer formally, if somebody's doing the design work, they become the designer whether they like it or not. So these quirks in the building regs that don't exist in the CDM regulations.
And then we've got a question about, do you have a template for demonstrating compliance beyond the existing guidance for thermal bridging and air tightness?
No, I think it's an easy answer, because we're not allowed to design the solution for you, and the regulator is very specific about that. There are companies who manufacture insulation products or systems who might have templates, but there's no kind of easy do this and it'll be all right type guide. Would that be fair to say, Sarah?
Yeah. So, and then we've got, if I bought a property that had work carried out 1 or 2 years before, when do I take on that responsibility? How do I get clarity? The vendor had the building control sign off. So there is an online public register that you can look at for all properties in Cornwall and the Isles of Scilly, because we provide the building control function for the Isles of Scilly as well. And that will show you what building controlled work has been done and whether it's been signed off or not. Unfortunately, most of the legislation that we have is aimed at the building owner. So if you are now the building owner and there is work involved in the building, we would unfortunately take action against you.
I was going to say a good example is a loft conversion. If you buy a house with a loft conversion,
and loft roomers, estate agents like to describe them.
You would want to make sure there was a building regs completion certificate for that loft conversion. If there isn't one, and our records go back a fair number of years, it differs depending which bit of the county you're in, because we inherited records from other district councils before we became a unitary. But all the same, the seller should have a completion certificate, or at least a building control paperwork or something like that, to demonstrate they went through a building control process. If they don't, you are potentially buying what you might call a lemon. And when you buy that, you might then be the person that's obliged to put that unauthorized work correct, because you own that building, you bought that problem, if you like. Our ability to prosecute you changes slightly, if we're talking about the harsh end of things, but you don't just excuse yourself the problem because you didn't do it and you just bought it like that. Speak to your solicitor about the buyer and seller information form very carefully, because there's a process where the seller is meant to declare all that stuff, but you also, as a buyer, you'd be well advised to ask some pointed questions.
And then we've got, are there still 2 routes for building control notification in domestic properties? So there is the building notice route and there is the full plans route. So there are still 2. You just need to be aware that a building notice cannot be used for anything that has any commercial works in it, and that would include a holiday let. So if you're renting your property out, then those have to go onto the full plans route. I've got a question: how are you dealing with private building control companies that have gone out of business?
Okay, do you want to cover that?
That's my current area of expertise. So there's a lot of companies that have not necessarily, some of them have gone out of business because the status because of the Building Safety Act has changed from approved inspector to registered building control approver. Some companies didn't make the switch. Some companies weren't allowed to make the switch by the Building Safety Regulator. And there are some companies that have just gone, actually, we don't want to go through that process. So any work that hasn't been taken over by another private building control company comes back to the local authority. So we do have significant amount of those thousands of them that have come back to us that we're now trying to address.
So it's worth highlighting that if you're using a private sector building control provider, they can go bust, they can go out of business, they can have sanctions put on them, they can have their license removed, and they can also choose not to carry on with your project because they don't like the way it's looking, or then whatever reason they choose to come up with. So in those cases, all of those, so you've paid them, and they may be within their rights, they may not be, to keep your money, because they may think they've already spent your money on inspecting your project, and you've spent it up already and you still haven't got a compliant building. So there's many reasons why those private building control provider applications, if you like, may end up what we call reverting to local authority control. So we effectively get to pick up the bits, if you like, when it goes wrong for whatever reason, or that private company decides they don't want to service your project anymore. And unfortunately, we have to charge for our time in sorting the mess out. So you'll have already paid them, and we might ask you to pay again, because we have to cover the cost of sorting it out. So it's an interesting point, and I would say do consider that when you choose your provider.
We've got one more popped up. So I've popped the link to the building control register of applications in the chat. So somebody's asking if they're looking to buy a commercial building with a residential conversion, can I ask you to carry out an inspection on my behalf? So we're only legally allowed to be the regulators for building control work, so we cannot do extra inspections as a surveyor. So you need to get an independent surveyor to do that sort of inspection for you. If they've had work done, there should be a completion certificate, whether it's from us or a private provider. It should show up on the register, so that should show up that the building work's complete. Just be aware that the building work completion certificate says that at the time it's for what we've been able to see, so you cannot rely on that when you're buying a property to know that everything is perfect, because
you need to
we
do
don't
your
see everything.
own due diligence, essentially, to make sure that one, what they've got approval for is still what it looks like, as best as you're able to ascertain. So they haven't changed stuff since without approval. And secondly, that it isn't a building control certificate is not an insurance product. It's not a warranty. It's not a guarantee that everything is perfect. It's just something to say that something was overseen, and as far as we could tell at the time, it appeared to be compliant. So do your own due diligence. And I'd always say it's a bit like buying a car. Somebody might say, yeah, it's got, here's my MOT history, here's the service history, here's the this, that, and the other. You might still choose to have an RAC or an AA inspection on that car, just because, well, that certificate might be 12 months old or 8 months old, or you know, the MOT only checks certain things, it doesn't check everything. So I would say with any building, you still need to do your due diligence, really. And if you need a pair of eyes on it, there's plenty of qualified surveyors out there who can offer a variety of sort of qualities, if you like, of surveying report for you to help you understand that.
And Judy's asked if we'll be doing another webinar. So we do training events throughout the year. So if you email, I'll put up our email address in, we could add you to our mailing list.
We do specific events for sort of designers, particularly in contractors. So for people whose, if you like, day job is designing or doing contracting work, and therefore they're dealing with the building regs on every day. Again, if you've got a specific premises and you operate a premises, or you're a business and you've got a complicated premises, you know, by all means come and have a chat to us, and we can help you perhaps a little bit understand how the building regs might apply to your building. We can't do the design for you. We're not surveyors or designers in that respect. But again, if you've got a fairly big campus or a you know, complex building or whatever that you operate a business out of, or a series of buildings, and by all means, we're happy to have a chat with you just to sort of look at your situation specifically and help you understand sort of where you might want to go.
I think. Yeah, no, I was just going to copy this. So there is also LABC Front Door, which is a website for practical advice for householders. So that's a good starting point for learning about the building regulations in something that's not too technical, a way of putting it.
Gosh, this is obviously yeah, people are getting carried away now, right?
So do you need to have BC for a roof replacement on an old outbuilding? So it depends whether the outbuilding is exempt from building regulations or not. So it depends how close it is to an existing dwelling and the use of the outbuilding.
And the size of it and what it's built out of as well.
Yeah,
so
it's not good. So yeah, a bit more information.
Your best thing, Jono, is probably to send us an email at that email address, buildingcontrol@cornwall.gov.uk. Tell us what your problem is. If you've got any drawings, pictures, photos, that's always helpful. And then we can try and come back to you to either arrange a phone call if necessary, or try and answer your question, or signpost you to something that will answer your question. As I say, I think probably one point to make is that when people contact us, part of the art of being a building control surveyor is people often don't ask the question they needed to ask. So we often have to kind of fish around a bit to understand what's actually happening, or the bit you didn't think you needed to tell us, because that is probably sometimes the key bit to giving you the right answer. So the more information or understanding we've got about what you're doing, the more accurate or useful our reply is going to be. We appreciate it's not people's fault. They sometimes don't know what to ask or what we need to know, but sometimes a few photos at some distance so we can see the situation and what's next door and that kind of thing can be really helpful, because we can give a far more useful reply straight off then. Thank you very much. Well, so quite an impressive attendance, so thank you.
Yeah.